All right, so here we are. This is CNIT 121. We're here at doing Module 7 today. I'll talk about that, and then later on I'll demonstrate the new project, which is not due until way in the future, but I did add a new project to the course, and this is just where you analyze an iPhone image. There's a NIST digital corpora site where the National Institute of Standards has posted images of things for forensic training, and they had some iPhone images there, and I found one. It's very similar to analyzing the Android we've already done, but it's certainly a good thing for people to practice analyzing an iPhone. So here we got, today's class is mainly about the structure of the U.S. legal system, which if you watch TV shows like Law & Order, you already know a lot about it, I imagine. So, of course, as you know, you typically have a jury trial in a criminal case where people listen to the evidence and determine a verdict of guilty or not guilty. The plaintiff in a lawsuit is the person initiating a lawsuit. That's in a civil trial, not a criminal trial. And the defendant is the person who defends themselves, who has been accused of something and who faces some kind of punishment if found guilty. Common law is based on case law and precedent. Precedent is old decisions made by the court which then change the law. You can refer to the older decision and say this new case is like that old case, and that determines the law. So these are laws determined from previous court decisions, and this leads to the tension that we're seeing very dramatically act out with the current Supreme Court. They call this legislating from the bench. For example, Roe versus Wade was huge. There was a huge argument in America about whether you should allow an abortion or not, and in the 70s, I think, the Supreme Court ruled that abortion was legal in the whole nation, and they created, by making that ruling, a precedent which made abortion legal. And the legislators in the House and the Senate very much did not agree and said we want to have state laws or even other federal laws that would overrule that. And that battle has lasted for 50 years, and now you see the left won in the 70s, and now the right has won now, and removed that. So it's gone back for every state to argue about abortion and for the feds to argue about passing abortion laws. So this is kind of a contradiction. Some laws are passed by the courts, or some laws come from previous court decisions. Other laws are passed by the House or the Senate, and they can battle over who has the right to make a decision and which one should take precedence. So anyway, so civil law is here. It's one of the common kind of law. That's the type that doesn't usually lead to prison terms, but to financial penalties. Criminal law leads to prison terms. And in civil law, in civil cases, somebody has to sue. You can choose not to press charges. In a criminal case like murder, the state may prosecute you even if there is no person to complain. All right. So we got constitutional law, statutory law, and regulatory law. Constitutional law is federal, of course, based on the Constitution. Statutory law is legislature laws written by the legislature. And regulatory law is rules you have to obey, like the stuff we hit a lot in security, compliance regulations. Like I was mentioning before, if you are a bank, there are a bunch of compliance regulations limiting what you can do. You must have financial disclosures, and there are privacy laws, and that, I think, is largely why a bank has to watch and not let their employees have other financial jobs they don't know about on the side, because they might be leaking confidential information from the bank to competing agencies and things like that, and they need to control that to obey regulatory law. So you got the court system, and as we all know, the Supreme Court at the top, and at the bottom, many other courts. And this, by the way, is also big in the news right now because of Eileen Cannon. The FBI seized Trump's boxes of documents from Mar-a-Lago, saying that those boxes contained government records that were not his property and that he had no right to have. And he sued, asking Eileen Cannon, a district court, a lower court judge that he had appointed, saying, you should let me have a special master to review these and decide whether I have the right to have them, making a very specious legal claim. So at one of these lower levels, she is making the decision to delay that case greatly by causing a special master and changing the deadlines and trying to delay it in order to please Donald Trump. And there's a new appeal from the government side saying she has in fact no jurisdiction over that, and she has exceeded her jurisdiction. She has no right to make any decisions in this case. It should go to someone else. And that's one of the many issues currently being decided at a higher level. Anyway, we have many lower courts review things, but you can appeal things, and then they can go to the Supreme Court. Usually the Supreme Court will just refuse to look at it and say the lower court has jurisdiction and there's nothing wrong with what they did, so we refuse to engage this. But a very small number of cases, the Supreme Court decides to step in, saying they do think there is reasonable argument to say that what has happened at a lower level is not right, and they're going to step in. And there is no higher place to go than the Supreme Court, which is also currently all over the news, because there are a lot of people very angry at recent Supreme Court rulings. Basically anybody on the liberal side is very angry at the far right swing of the Supreme Court, and they're also mad that Clarence Thomas refuses to recuse himself from cases in which his wife has a very strong interest. And if you don't like something the Supreme Court does, there is essentially no recourse at all. There's no higher court to go to. The only thing you can do is try to impeach a Supreme Court justice, which has happened a few times, like impeaching a president, but it's a very difficult thing to do and very rarely results in anything changing. So you got appeals courts. If you get a court decision you don't like, you can try to appeal it, claiming that something is wrong, like your lawyer was incompetent or important evidence was lacking, and move to a higher court. All right, the federal courts, and we talk about the Supreme Court and federal appellate courts and all these things. I don't think it's necessary to know all the details of these. All right, and here's some things you'll see, like family court for child custody and traffic and juvenile and probate. There's a lot of these different areas. All right. New York, and there are districts all over the place with district courts, like 2 of them in New York City, and so on. All right, so in the courtroom, this is more important to us because the main activity as a forensic examiner is you will serve as an expert witness, so you do need to understand what happens in the court to some extent. So first they select the jury, they bring in a pool of potential jurors, and then they examine them one by one, asking questions from the judge, the prosecution, and the defense to determine if the juror appears to be biased, and if they satisfy them that they're not biased, then they can be chosen and sit on the jury. Then they swear an oath, they have instructions, there are opening statements from both sides, then there's testimony and evidence, and this is where you would have your expert witnesses on both sides come in and make statements about the computer evidence. And then you have closing arguments. The juries get instructions explaining to them exactly what the law from the judge. The judge says, here's what the law says, so you're trying to determine these specific things. And then they retire to a private room where they deliberate and argue in privacy for some period of time until they reach a verdict, and then they deliver it to the judge. And after the verdict comes out, if the verdict is guilty, then there's a phase of sentencing where the judge decides how much punishment there will be based on the recommendation from the jury. All right, so voir dire is the process of selecting a jury where they ask the jury questions to see if they appear to be biased. And there's a similar term, I forget the official term, there's a similar term for the talking to the expert witness, where the expert witness must explain their credentials and their experience and their training and answer questions about that to satisfy people that they are in fact an expert that can be relied upon. Might be the same thing called voir dire, I forget. I know it's to see, to say in Latin, but I forget what it is. All right, if you violate the rules of the court, you may be charged with contempt of court, and you can be sent to prison for that, and that is what happens to journalists who refuse to reveal their sources. They can be imprisoned for contempt of court, and it appears like it's going to happen to Steve Bannon, who was ordered to appear and refused to appear, and you can get contempt of court for that. All right, so you make your opening statements, and you have direct examination when you examine a witness, and cross-examination when the other side comes in to ask more questions of that witness. Do deliberations, get a verdict. All right, so a criminal trial is initiated by the government on behalf of the people and typically has a risk of going to jail. A civil trial is usually about money, and a civil trial only happens when someone complains and says, I have a complaint. Something bad has happened to me. My landlord refused to fix the heating, and I want money. Or, somebody failed to live up to this contract, and they're asking for money, basically. And that's what they're battling about. All right. So constitutional law is where you can where you compare you complain that something you're guaranteed in the Constitution has been denied you, typically one of your rights. So the First Amendment says that you have free speech and freedom to practice your religion. All right, and so you can sue if you feel like those things have been violated. The Fourth Amendment is really important. A qualified expert witness, yes. Yeah, there's various standards we'll get to later, and your expert witness must meet certain criteria to be an expert witness, and they must use certain techniques that are accepted, and you must justify this. You must say, you have to turn in your resume and your credentials, and it's examined by both sides, and people can say, in fact, I've seen it happen in court. The expert witness was there, and they said, you had to pass a certification exam to be qualified for this, and you flunked that exam 4 times before you passed. And they brought that up. And the expert witness had to admit to that, and that was the sort of thing which might cause people to not believe what that expert witness says so much. So you do have to defend your credentials, and the way you handle that determines how much the jury believes what you say. So you have to be able to present yourself as competent and confident, and you have to impress people. And if you fail to do that, if you're not a good communicator, if you're insecure, if you don't speak clearly, then you're a lousy expert witness. You don't impress people. It's a little bit like running for office. You have to be able to present yourself in a way that makes people trust you. All right, so the Fourth Amendment limits what the government is allowed to do when searching for evidence, and this I hear constantly in this field. There's issues of whether the police are allowed to use GPS evidence, camera evidence, evidence they find on cell phones, and so on. All right, so evidence seized without proper legal basis, like a warrant, then it will often be determined that that evidence is inadmissible, and they can't use it in court. There's also something called fruit of the poisonous tree. If you do something illegal, and then some other evidence comes as a result of that, that whole chain of evidence is forbidden in court. You did something illegal, and then other things resulted from that. So all of that evidence is now excluded. All right. And so here's a motion in limine. This is a hearing held before a trial to suppress evidence. Before the trial starts, that's why you have to hand over evidence to the other side. I remember I've had jobs like this where you have to make 2 copies of the evidence, and then have to make very clearly proof that you have perfect copies on both sides. So one goes to prosecution and one goes to defense, and before the trial, they examine that, and then they can complain. They say, this piece of evidence is inadmissible, in my opinion, and they issue a motion in limine, and then there's a hearing before the judge without the jury where they argue about whether that evidence is okay or not, and that evidence may be excluded, and then the jury will never see it. All right, and we've talked about search warrants. If you have to get a search warrant, like what happened at Mar-a-Lago, you have to go to a judge and say, we have probable cause that the evidence that there was a crime committed, and that there's evidence of that crime in this location. And therefore, we want to go search that location, and we have probable cause that a crime has been committed and that evidence will be found there. You have to prove that, and the judge has to approve that before you can go search, because, of course, you're invading somebody's house or car or other property. And so you are, under certain circumstances, however, you can search without a warrant, and the most common reason is for exigent circumstances. If there is some emergency, like someone has been kidnapped and you think they're dying somewhere, then you're allowed to just barge into people's houses and search without a warrant because it's an emergency. There may be arguments later over how much you're allowed to use evidence you find, but you are allowed to search things without a warrant, under the ticking bomb, that sort of thing. Obviously, it's an emergency, and it's more important to find some evidence to stop this immediate problem than it is to worry about the admissibility of the evidence later. And there will be special rules will appear there. Then there's the plain view doctrine, too. If there's something they can easily see in public, then they do not need a search warrant for that. All right. Yep, and swatting is another one. That's right. So you call somebody, you fake a phone number, you say, I've got a gun, I'm about to kill my whole family here. You say that to the cops, and then the cops will just, of course, barge in the door, bring in SWAT team and everything, and that's what they should do to deal with an emergency situation. They don't sit around waiting for a court order. But, of course, it's easy to get people hurt if the report is false. All right, so there are errors made in court proceedings. There's rules for procedures and so on. And one big issue is standing, by the way. This one's, again, in the news. That's why I say you learn a lot about this just from the news. I was pretty surprised and troubled by Biden's decision to forgive student loans, because that's illegal. It seems plainly illegal. The president does not have the ability to spend money like that. That has to go to Congress. And that's what Biden and Nancy Pelosi said a couple months before that. But what Biden did, he was persuaded to issue this order forgiving student loans on the grounds that even though it is on its face illegal, it is probably not possible to stop him, because the Republicans are bringing lawsuits trying to stop this because they don't like it. It's basically a move towards socialism or something. But the problem is nobody can actually sue to stop it unless they prove they have standing. And in order to have standing, they would have to show that this law will harm them. And in fact, how can you prove that it hurts you for somebody's loan to be forgiven? It's not obvious that that hurts anybody. Now, the Republicans' claim is, it means you have to get that money somewhere, you'll have to raise taxes somewhere, but that's really indirect, and so far, that seems to be working. Even though it appears to be an abuse of power, it does seem not to be possible to reverse it, although the lawsuits are still... Nobody has yet been able to find any way to get enough standing to sue to stop it, so it may take effect, which will, of course, be nice for the people with student loans. All right. So digital surveillance is a big deal with us, people monitoring things. Even if the lawmaker had a student loan, that's right, loan forgiveness would not be harm. Well, certainly the people with student loans, I don't see how they could possibly have standing to complain about the law, although if someone tried that on the grounds that because of the tax structure in their state, forgiving this loan would somehow result in them owing more taxes or something, but I don't think they're succeeding with that argument. It would be mighty hard to come up with a way this is hurting you. All right, so digital surveillance is all over the place. People get search warrants and seize your email and such, and of course, the most directly applicable to us, they seize computers and cell phones, and then you examine them. Another thing they use is stingrays. This is quite common now. They drive a truck around into a neighborhood, and they run a device called a stingray, which is a fake cell phone tower. And all the phones in that neighborhood will get a signal that's stronger from that tower, so they will connect, and their phone calls are now going through the stingray device. And therefore, they have a man-in-the-middle position, and they can wiretap your phone that way. That's the modern version of the wiretap. It used to involve moving wires at the phone company. And therefore, the problem with this, of course, is it's not targeted. If you just park in a neighborhood with your truck, you're going to man-in-the-middle and intercept all the phone calls in that area, clearly not just the ones that you have a search warrant for. You probably have a search warrant for one person's phone, but you're getting a whole lot of phones. And so there are legal issues there, but they seem to have gotten around it, I think on the grounds that they can collect all that data, but they can only use the stuff that matches the search warrant, the authorization they have for it. Anyway, a pen register is an electronic device that captures telephone numbers, and this is another way to do it. You do not intercept the voice calls and listen to them. You just get a list of what phone number connected to what phone number at what time and for how long. That's all you get, and that is considered a much lower level of invasion, and it doesn't require as much court authorization to do that. Anyway, there's a lot of argument about this, and many people I see constantly in the news, people arguing about whether you have the sufficient authorization to do the interceptions that people are doing on the telephone and on computer networks. Then there's GPS tracking. Now, you can attach a GPS tracker to somebody's car and record them, and that seems to be something you can do without a warrant. Whether you can examine the GPS data on their phone or on their car's GPS is another issue, and I'm not quite sure what the rules are on that. There's quite a lot of rules on these things. Of course, as a forensic examiner, you don't really need to know the details of these rules, which are constantly changing. What you have to do is you have to make sure that you're authorized to do whatever you're doing. So one simple rule that saved me, I worked on a lot of cases like this from a different position. I was basically a forensic examiner. They didn't call me that, but I was working with data to be taken. But every time anybody asked me to do anything that sounded fishy, I would send a letter to both sides, the prosecution and defense, and say, I have a request to do this thing. Is that okay? This is a good practice. But you do have to know what the parameters are to make a reasonable decision of whether something is all right. For example, on one time, the defendant called me and said, I want a list of I want to know how many people have claimed my product was defective. And this person was being sued by the Federal Trade Commission, and I was handling the database, and I knew enough not to answer that question. I said, well, I do not know if I'm allowed to answer that question. Let me talk to my boss. And they were close to have to send letters to both attorneys saying, we have a request from the plaintiff to release certain data about the case. Is that okay or not? You have to know, don't make a decision. Don't do something. Don't say no, don't say yes. Say, wait, that's not my call. That's up to the judge and the plaintiffs. I will not ignore you. I will record your message, and I will absolutely, in writing, pass it on to the right people, and then have an answer. You got to make sure you're not stuck making a decision that's not your right to make, like poor Eileen Cannon, who appears to have made a decision that wasn't her right to make. All right. So then there's traffic stops, what you're allowed to do at a traffic stop. And of course, another big issue is when you cross an international border. They have the right, apparently, to seize your cell phone and all your devices and search them without a warrant. Yeah, you can see it as you have to protect yourself, and also you just have to understand your place. I'm just a middleman. I'm just the servant of the court here. I'm not here to punish evildoers or make judgments. I'm here to just find out the truth. You have to understand your role in the system. All right, and then, of course, the Fifth Amendment, we're hearing a lot. If you are on trial, you have the right, with some exceptions, to refuse to answer questions. It says that might incriminate you. So that's something your attorney would advise you about. All right. And the Sixth Amendment doesn't affect us very much. This is that you have the right to a speedy trial. Unfortunately, there's huge delays in a lot of trials, but that's usually not something the forensic examiner worries about. You let your client of the attorney, and the timing is up to them. One thing to know, though, is that when you have done a forensic examination, don't throw anything away. Keep a copy of your report and keep the original evidence locked up. You keep that for years. You usually want to keep it because you never know. The case might go to appeal. It might come back and go to appeal years later. Years after you think it's over, it might be appealed, and they might come to you and say, we need to see that evidence again. So, you want to charge your client fees for storing it, and you want to store it for a long time. At least 7 years, maybe even longer if you're doing criminal cases. That stuff may be required many years later. All right, then there's the Wiretap Act. This is pretty tough. Intercepting telephone traffic of any time is a very serious crime. There are a lot of ways to do it. It is technically quite easy. You can do it with just a $30 SDR USB dongle on your computer. You can intercept wireless telephone traffic, but if you do, it's a monstrous crime. So be aware of that. That's the Electronic Communications Privacy Act. All right. The Foreign Intelligence Surveillance Act. Yeah, use a drum. Well, there are technical ways to make it less obvious that you've done it and try to hide the fact that you've done it. But the fact is, if you've done it, you're in legally dangerous territory. And this is why you need an attorney if you're going to be a security researcher of any kind. Because even doing things that you think are completely legal might be accused of being illegal later. You might be accused, and we need somebody to help you navigate the difficult waters of these laws. Right, the Foreign Intelligence Surveillance Act is intended to protect the U.S. from international espionage, and it was amended by the Patriot Act after the 9/11 attacks to be much more vigorous at investigating what foreigners are doing in the United States, and this has led to many, many controversial issues of wiretaps of phone calls where one member is a citizen and the other member is foreign, and how much of that evidence are people allowed to use, and so on. The Computer Fraud and Abuse Act is the most important one for penetration testers. This is the one that limits what you're allowed to do on a computer network, and it is written in a way that is badly out of date. At the time it was written, there was no World Wide Web, and only a few computers were used for international commerce, and that's what it was intended to protect. But the way it's written, any computer that is used to transmit data across interstate boundaries is protected, and that's, of course, every computer of every kind now. So if you go to a website and right-click and view source and notice something about the structure of the website that the owner of the website did not intend for you to see, you have apparently violated the CFAA. You have now discovered something that they didn't intend for you to see, even though you didn't enter a password or do anything you normally think of as hacking. That's why it's a problem. And so this is another reason why you need an attorney. Even the smallest amount of security investigation might expose you legally. Then there's the Espionage Act, and a bunch of other versions of the computer parts of this. Trespassing, committing fraud, distributing passwords, damaging a computer. All these are related crimes. All right. And then CALEA. CALEA is a big one. CALEA is what lets wiretaps happen. And in order to make wiretaps possible, the phone company is legally required to make provisions for wiretaps. They have to technically have a way to let the police tap a call when they come in. And there is no such thing on the internet. They've been trying for decades to get it. Your internet service provider is not required to add the capability to wiretap your internet communications, and that's why you can, for example, have an internet coffee house where people wander in, they connect to the network, and the owner of the coffee house does not even know who they are, doesn't keep track of who they are, doesn't keep any logs. If they had CALEA, you would have to have logs of all that. They'd have to know who you are, because they would have to find out if there's a wiretap order on you and then tap that one person. It would require technical and administrative changes, and so far that has never happened for the internet yet. And then there's the edge cases like internet-based telephony, like Skype, and huge arguments go back and forth, or whether that's internet traffic or phone traffic, all the various strange new inventions that are sort of like the telephone but not exactly. So the Patriot Act gives the government enormous powers to search things in the case of suspected terrorism. And I say, I wouldn't even worry too much about the details from your point of view. You just want to make sure that you're doing what an attorney authorized you to do in writing. And then your defense, if you're not allowed to do it, is, well, that's what the attorney told me, and I'm not an attorney. I'm not qualified to judge the law. All right. However, people may come, I mentioned this last time, and ask you to do illegal things. Like one of my students said, someone called and said, I want you to investigate my wife's computer to see if she's cheating on me, and that is completely illegal. So you do have to know enough to be aware of what requests are outrageous and illegal and refuse to do them. You know, I would only investigate your wife's computer if your wife will sign a document saying she authorizes me to investigate that computer. That would make it legal, I suppose. Even then, I would recommend not taking the business because, as any cop can tell you, getting involved between a man and a wife is a dangerous place to be. Everyone's likely to end up hating you. You'd probably be wiser to just refuse to take that business anyway. All right, and the Digital Millennium and Copyright Act makes it illegal to copy protected things and to overcome encryption and other protections in order to make it possible to copy protected things. Does that apply to looking at a spouse's phone? I think it does, Mobo. I think, again, I'm not an attorney, but I think if you look at somebody else's phone, I think you are invading their privacy if you're doing it without their permission. I would guess perhaps if the phone is locked and you only look at what pops up on the front of the phone without logging in, you might be able to argue that's in plain view. The other person might be able to argue that that has an expectation of privacy, and that's where it gets a little thorny. Yeah, but I would think that's quite true. And there may be some special circumstances if it's your spouse. I'm not sure if married couples have the same rights of privacy with respect to each other. I would think not, because plain view becomes different. I'm just guessing. You really need an attorney to make those fine calls. Anyway, So there's copyright infringement and other issues there. George Hotz was a famous case. Geo Hott was the guy that figured out how to hack the Sony so you could do unauthorized things on it, and they sued him under the DMCA. And years ago I used to find vulnerabilities in college websites, and then people said I was violating the CFAA, so I started finding vulnerabilities in Android apps, and then they said I was violating the DMCA. And so that's why I said, you need to get an attorney. There's just no way to do anything without some degree of legal risk. Anyway, so evidence admissibility. There's the Fry test that says you must use science that is demonstrable and not experimental, and that's why things like hypnosis are not admissible in court, and lie detector tests and things like that. They have not been determined to be sufficiently scientific and proven. Here's the Dalbert Test that says you have to test your tools and make sure they have benchmarks showing that they're working properly and have the acceptable error rates. And there are federal rules of evidence. So here's the general statement. If the technical knowledge will assist the trier of fact to understand the evidence or determine a fact in issue, a witness qualified as an expert witness may testify. And like I said, you have to prove that you have knowledge, skill, experience, training, or education sufficient to be recognized as an expert witness. And it's not like a certificate you put on your name. It's just a judgment made in court based on your credentials and how you present yourself. It's not like you have a CISSP that makes you an expert. It's that might be one of the credentials, which is part of convincing people you're an expert, but what really matters is if you convince the jury that they trust what you're saying. And in particular, if they trust you more than they trust the other expert witness in the event that the two of you disagree about something. All right. And the expert witness is the special kind of witness whose opinions become evidence. Other witnesses, their opinions are not evidence, but the expert witness has an expert opinion, which can be treated as evidence to the extent that you trust that expert. All right. So the rules of civil procedure. And so you have to have reports that state all the opinions you're going to make and the reasons for them, the facts, the exhibits, and the witness's qualifications, like I said, including a list of all your publications authored in the previous 10 years, a statement of how much you're being paid. These are things that must be there, a list of your other cases that you've testified on, and all these are things that are available to both sides and to the jury so they can know how much they should trust you. All right. That's the story. Federal agents, evidence and hearsay. Best evidence, this is why you have to keep the original thing that was seized, cell phone or computer or something, in a safe. That's called best evidence. You have to show up in court and say, this right here, this is the computer. This computer contains this evidence. Now, you work with copies of the evidence, but you keep the original thing. If you don't have the original thing to bring to court, then you don't have best evidence. All your evidence is just secondary and of less value. So if you want to win in court, you have to preserve that original item. This, among the many strange things about this, is if you're accused of something, they will swoop in, like Rudolph Giuliani. They seize all your cell phones, and the MyPillow guy, Mike Lindell, they seized his phones, and he said, I was using that phone. I need that phone. I don't have a backup. Well, you're hosed. Just the fact that you're involved in a legal case means they're going to seize that phone, lock it in a safe, probably for years. You're not going to get it back because they need to preserve the best evidence, and they can't violate the chain of custody by letting you borrow it to, like, copy the phone calls or something, and therefore it's very inconvenient. And especially since, so that's an issue to know. Doesn't that put the evidence in the case at risk? Well, I'm not quite sure what you're bringing it to court. Well, no, it doesn't, because when you bring it to court, somebody is still responsible for it. That does not break the chain of custody. There is going to be somebody there who is the agent who writes on the chain of custody. I took it out of the safe and I brought it to court and I stayed there and watched it to make sure that that nobody messed with it in court. Nope, doesn't break it. But it has to be on your chain of evidence custody, though. Who brought it to court? Who's willing to testify? I did bring it to court. I didn't leave it unattended. That sort of thing. All right. And so then you've got some information about the European Union, which I haven't worried about much. The only thing about the European Union that's worth knowing is GDPR. They were the first to have really strong privacy laws. And the General Data Protection Regulation is responsible, lets miners erase their data off social networks. And I think this is the one that makes every bloody website pop up a thing about cookies all the time, because every website is technically storing some information on your machine about what you're doing, and now they have to inform you of that with, is it okay that we store cookies? And so that's a big deal. And California now has the California privacy regulation based on the GDPR. It has not spread to the whole United States yet, but it probably will. All right, and then there's privacy legislation in Asia. China, of course, has enormous restrictions on what their citizens can do. They filter the internet. They constantly ban it. Every time there is a political scandal, they keep banning certain keywords off social networks and so on. So they're very strict dealing with their own citizens about the internet. And India has got a new law which is greatly battled right now, which would greatly restrict the use of the internet, and people are currently arguing about it, and they just delayed it another few months. I saw a news article go by. Australia also hit the press. Australia, about 8 years ago, the new prime minister said, I'm going to put a security device protecting us that will on the internet that will remove all the pornography and all the malware and hacking off the internet. And his technical experts said, don't promise that. There is nothing we can buy that will do that. But he said, I'm going to do it. And so they spent years trying to do that. And of course, they couldn't. There is no such firewall or other device that can do anything that good. But that's, of course, one of the things they're trying to do here. Remove all the illegal content, remove all the attacks, and remove all the stuff that violates their laws about political speech and such. And, of course, it's all pretty ineffective. It might stop most ordinary users from seeing stuff, but people that know things like VPNs and encryption are always bypassing all these defenses. All right. Well, that's it for the module. Let me stop this.